Okay, so welcome today to the Disciplinary Process, Fair Outcomes and Low Risk webinar that is being facilitated by HR Recruit and Nathan Andrews. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will discuss things we should consider to help reduce risk for the organisation and good practice guidance to ensure a fair outcome from the employee. If you've got any burning questions or comments during the session, please put them into the chat box facility and we will cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the webinar. Thank you.
Thank you, Jo. Good afternoon, everyone. As you know, my name is Nathan Andrews. I'm joined today from Fretton's Solicitors, where I'm the head of HR services. I'm not a solicitor, I'm an HR specialist. I have 20 years experience practicing HR and specialising in employee relations management. So I'm joining today to give everyone an overview of handling a disciplinary process. Some of you, or the majority of you, may be HR practitioners, so this may be just a good refresh. Or if you are in a line management role and haven't handled or experienced handling disciplinary processes before, then this will give you a good basic overview of the process to follow to ensure that you deliver fair outcomes and that these outcomes are at low risk to the organisation. As Jo says, if you have any questions, please use the chat facility and we'll cover them at the end of the webinar. So what we're going to cover in today's session, we're going to look at the difference between disciplinary issues and grievances. We'll then talk about the ACAS Code of Practice on discipline and grievance. We'll also talk about the difference between disciplinary rules and procedures, the difference between misconduct and gross misconduct. That's an important differentiation that you should understand when handling matters around misconduct or whether they are gross misconduct. We'll also be talking about dealing with particular issues. We'll discuss conducting a disciplinary hearing and reaching a decision at the conclusion of any disciplinary procedure. And then we'll cover the right to be accompanied and the appeal procedure. Nothing in this webinar is intended to be legal advice. If you are handling specific matters within your own organisations, whilst this will give you a framework to follow, if you are dealing with complex matters, you should seek independent advice. So what I want to do first of all is talk about the difference between disciplinary issues and grievances. So if you are an experienced HR practitioner or line manager, you will be aware that disciplinary issues often arise when problems relating to conduct or performance are identified by an employer who looks to address their concerns through established policies and procedures. In this particular circumstance, you would be looking at your disciplinary procedure and your grievance procedure. Grievances, on the other hand, are raised by employees who may have concerns or complaints about their terms and conditions of employment or their work environment or relationships they have with colleagues. More routinely, we experience grievances to be related to either the work environment, but most typically relationships with work colleagues. So I just want to touch on the ACAS Code of Practice on discipline and grievance. So both employers and employees should follow the ACAS Code of Practice on discipline and grievance issues. The ACAS Code contains 4 sections. There's a foreword, which is purely advisory. There's an introduction setting out the general principles applicable to all disciplinary and grievance matters. And there are 2 further sections dealing with disciplinary issues and grievance matters, respectively. If an employee subsequently brings a successful tribunal claim, the tribunal does have the discretion to adjust any award upwards or downwards by up to 25% if either you or the employee has unreasonably failed to comply with any part of the code other than the foreword, which, as I've said, is purely advisory. The code is also complemented by a non-statutory guide, which provides more detailed best practice advice on handling discipline and grievance matters. Now, often when we talk about best practice, you can sometimes get eye rolls, but following best practice principles is important, as they should help you ensure that you have acted reasonably and that any dismissals under the general unfair dismissal scheme are procedurally fair. So following best practice guidelines is actually beneficial to you and the organisation if you want to help reduce or mitigate risk when handling any potential dismissals within your organisation. So I just want to talk about what are disciplinary rules. So disciplinary rules should set out the standards that are required of all your employees to which they apply. They should make clear to employees what is expected of them when they are at work, and they should also set out the consequences of breaking the rules or failing to reach the required standards you require of the individual in their job role. Now, it is advisable for disciplinary rules to be contractual terms so that any breach by an employee will be considered a breach of contract. The disciplinary rules should be specific, clear and fair, and they should reflect the needs of your organisation, including the type of work that your organisation undertakes, your working conditions, the size and location of your business. And it's also important to remember that one set of rules cannot realistically cover every situation, and you should therefore state that they are not exhaustive, so you don't have an exhaustive list. When forming disciplinary rules, your disciplinary policy should ideally be formulated by you as a business with the involvement of your employees and, where appropriate, with a trade union or other employee representatives. That's only particularly relevant if you are in a unionised environment. When formulating disciplinary rules, the general principles you should apply should include the rules being specific, clear and concise. We've already mentioned that. And they should also set out the requirements that are necessary for the efficient and safe performance of work to be carried out within your business. And they should also help to maintain a positive working relationship between line managers and the people that they manage. The rules should be readily available to all staff. So, for example, in the staff handbook, which should ideally be held on a company intranet. If that's not available, you could make it available in either electronic format. You could send copies to individuals by email, or you could even include copies on a company notice board if you have those available. It is important to remember that it's the management team's responsibility within any organisation for ensuring that employees know and understand your disciplinary rules. And for example, by giving each employee a copy as perhaps part of your induction process is good practice, because that means that you can ensure from the very outset that you have given your employees the relevant information they need to have regarding your specific rules that you will work towards. Employees should be made aware of the likely consequences of breaking the rules and the type of conduct which may warrant summary dismissal, so that is dismissal without notice. It is also usual for disciplinary rules to cover issues of misconduct and to specify that serious cases will be treated as gross misconduct. So that is good practice when you're drafting your policy to make sure that you cover those key aspects. So I just want to touch on the difference between misconduct and gross misconduct. Again, if you're an experienced HR professional or line manager, this will be fairly obvious to you. But if you're new to handling issues around discipline, this will be really useful for you to have in your toolkit. So misconduct is conduct which initially requires disciplinary action other than dismissal. So the misconduct is not so serious that it would warrant you dismissing summarily that individual for gross misconduct. Gross misconduct is a deliberate or willful flouting, if you will, of contractual terms, or misconduct that is so serious that it destroys the contract between the business and the employee. And we often talk about a breakdown in trust and confidence between both parties. So just to touch on misconduct in a little more detail. So misconduct is often a minor breach of company rules, policies, or procedures. It could be minor damage to company property. It could be unsatisfactory attendance or poor timekeeping. It could also be related to unauthorised absence, failure to meet appropriate or expected standards of work, although it is worth noting in such cases it may be more appropriate for you to draw on a capability procedure rather than your disciplinary procedure, depending on the nature of the failure. However, I make those comments being aware that not every organisation has a capability procedure, and it may be that they only have a disciplinary procedure in place to provide a framework for how to handle such matters. It's worth remembering as well that if further misconduct takes place, dismissal may ultimately be an appropriate sanction depending on the circumstances. So now I just want to talk about gross misconduct. So gross misconduct is a single act of misconduct that is serious enough on its own to justify the employee's dismissal without notice. There's no statutory definition of what constitutes gross misconduct. It is up to each employer or business to define what types of conduct will be regarded as gross misconduct in practice. It will also be important for employers to do this clearly so that employees and their managers properly understand the types of conduct that could lead to dismissal. So it's really important that you are clear on what you would consider gross misconduct within your organisation. Before dismissing an employee for gross misconduct, you should still investigate the allegations made and give the employee the opportunity to respond. That sounds fairly obvious, but sometimes I support organisations where they've missed that investigative step. And actually, that's really key before reaching any decisions about what you do when you're addressing issues of gross misconduct. Before dismissing an employee for gross misconduct, you should give them the opportunity to respond to any allegations made against them. So as part of your investigation process and as part of your any disciplinary hearing, the employee should have the opportunity to fully understand the allegations made against them and to be given the opportunity of presenting their case. And that's really important if you want to ensure that any decision to dismiss is a fair one. So in cases of gross misconduct, your disciplinary rules should indicate that such conduct may result in summary dismissal. So we need to make that clear so employees know that if they commit an act of gross misconduct, they could be dismissed without notice. Examples of gross misconduct typically include theft or fraud, physical violence or bullying, deliberate and serious damage to property, serious misuse of an organisation's property or name, deliberately accessing internet sites containing pornographic material, offensive or obscene material, serious insubordination, and the list goes on. So it is worth giving this careful consideration when you're drafting your disciplinary rules to make sure that you are clear on what you would consider gross misconduct within your organisation and that you make it clear to your employees. So I now want to move on to disciplinary procedures. So disciplinary procedures should be created to provide a framework to support managers. So your disciplinary procedures should be a tool which helps your line managers manage issues effectively. They should also help managers deal fairly and consistently with any problems that may arise within your organisation. And that's really important. You want to be seen to be acting consistently when dealing with issues as they arise. So we always advise that your disciplinary procedures should be non-contractual so that you can retain as much flexibility as possible when implementing them in practice. You should make sure that you do not act in such a way which could destroy the trust and confidence that exists between you and your employees. So again, that's making sure you act consistently and fairly when dealing with issues. It is worth pointing out we do work with clients whose disciplinary procedures are contractual, that if you do have contractual procedures, you need to follow those procedures carefully and to the letter. If you were to deviate from following those contractual procedures, you could leave yourselves exposed to a claim of a breach of contract, or if you were to dismiss in breach, you could also be subject to a claim for wrongful dismissal. So it's really important to be clear on the contractual status of your procedures. In an ideal world, they will be non-contractual, but as I say, we often come across examples where organisations have contractual procedures, and therefore we always advise you follow them to the letter with care and consideration to avoid any subsequent claims. Now, in terms of forming disciplinary procedures, I just want to touch on the concept of natural justice, which I'm sure most of you, if you worked in HR, will have come across. So the concept of natural justice requires employees to be informed in advance of any disciplinary hearing, of the allegations that have been made against them, together with any supporting evidence that you as a business will be relying on when making decisions later on. They should also be subject to an unbiased and impartial decision-making panel, and they should be given the opportunity to challenge allegations. We've already covered this. They should be given the opportunity to challenge allegations and evidence before you reach any decisions. Further, and once decisions have been taken, they should also be given the right to appeal against any decisions you have made when handling disciplinary matters in practice. So natural justice is a technical term in English law, and it essentially provides a rule against bias and the right to a fair hearing. That has now been largely replaced by a duty to act fairly and reasonably. So I mention this intentionally because you'll often hear, if you're a line manager, when HR is advising you that whatever decisions we take, it should be done fairly and reasonably. So when we think about the broad concept of natural justice in practice, we always advise that good disciplinary procedures should, bear with me, I've just lost my space, there we go. They should be in writing, they should specify to whom they apply, and they should provide for matters to be addressed without undue delay. They should also be non-discriminatory. They should provide for proceedings, witness statements, and records to be kept confidential, and that's really important. They should also indicate the disciplinary actions which may be taken and specify the levels of management which have the authority to take the various forms of disciplinary action within your organisation. So again, it should be making it really clear to the employees concerned how things will work in practice. Good procedures should also provide for careful investigation before any action is taken. It should provide for employees to be informed of the complaints against them together with supporting evidence. Again, we've touched on that before, but I'm reiterating it, that again, it's really important that you follow these guidelines. They should also provide employees with an opportunity to not only respond to any allegations made against them, but to potentially call witnesses at any subsequent disciplinary hearing. So again, these are points that you should consider when handling issues, especially around gross misconduct, where you may be considering terminating employment. Now, I'm only going to touch on a few particular issues that you may encounter due to time constraints, but the ones we most often come across is absence. So if you are managing issues around absence, you should ensure that employees know who and when to notify when they are absent from work. In cases of sickness, they should know when to self-certify, and they should also know when they need to provide you as a business with a medical certificate or a fit note. As employers, you should monitor absence levels by keeping good records, which show lateness and the duration of any absences, but also the reasons for absences. And often we encounter, situations where we're advising clients on absence-related issues, and often the reasons for absences are missing, and this is really important. So good record keeping requires that you not only monitor the duration of any periods of absence, but you also capture the reasons. By keeping these types of records, you'll also be able to identify employees who are regularly absent, and you'll be able to identify any emerging patterns, which will allow for problems to be addressed at an early stage rather than waiting for them to become more entrenched and more difficult to manage. So I just want to touch on absence on medical grounds. So absence on medical grounds typically include injury, disability, and illness, and they should be treated as a capability issue. There are other types of absence which may give rise to disciplinary issues. So, for example, it could be unauthorised absence, which, if you are experiencing, ongoing periods of unauthorised absence with an individual, that is absolutely a conduct issue that you would want to address proactively through your disciplinary procedure. Medical absences should be treated sympathetically and with compassion, and that goes without saying. It might sound fairly obvious, but it is one important point to remember. When considering how to handle medical absence cases, we always recommend to our clients that you consider how soon the employee's health and attendance may improve, whether there is a suitable alternative work available to give them during any period where they are experiencing health concerns or issues, what effect their absence will have on the organisation, whether there have been any other similar cases, and if so, how have you handled those? Again, that goes back to consistency. And you also want to consider whether the illness is a result of any disability, in which case you should bear in mind your statutory obligations not to treat an employee less favourably on the grounds of their disability or unfavourably for a reason relating to their disability. You should also not overlook your duty to make reasonable adjustments to accommodate disabled employees. So again, this is an important point to consider, and something we often talk to clients about when we're discussing issues that need to be managed around absence of medical grounds. It's about approaching the situation cautiously and making sure you're fully aware of the situation and all of the circumstances before you start to make decisions about what you do next. Okay, and then we want to touch on unexpected absences. So we always advise that all unexpected absences should be investigated without delay, and the employee should be asked to give an explanation for why they've been absent. If there are no acceptable reasons for their period of absence, then the matter should be treated as a conduct issue and dealt with under your disciplinary procedure, in which case the employee should be told what improvement in attendance is expected, and they should be warned of the likely consequences of failing to improve. And that's really important. So if you're dealing with someone who is having regular unexpected periods of absence, then you need to manage that robustly, make sure you gather your documentation and make sure you're very clear with the individual concerned what you expect in terms of improvement. Okay. And then another issue that we deal with, and I've dealt with fairly recently actually, is when you're dealing with issues that need to be investigated and there is an ongoing police investigation. So employees are, oh, actually, if I jump to slides, Joe, can you see?
You're on dealing with particular issues, so you're still on the previous slide.
Okay, bear with me. Let me jump back, guys. I'm jumping ahead. If we go back to poor performance, can you see that, Joe?
Yeah, poor performance highlighted, yeah.
So just touching on poor performance, I'm not going to go into a huge amount of detail on poor performance because we haven't got time, but it is an important one to cover. As we know, employees are contractually obliged to perform to a satisfactory level during their employment. It's important that you set realistic and measurable standards of performance for all job roles within your business, and that is really helpful later on should issues emerge. This is an obvious one, but careful recruitment selection can help to minimise the risk of poor performance. But again, it is your record keeping and it's how you set out your standards for performance to your new employees is what makes it easier when you're managing issues later on. You should explain the required standards and the consequences of failing to meet those standards to all of your employees at the very outset of their employment with you or your business. And if you're dealing with someone who's just been newly promoted into a role, again, the same principle applies. Make clear to them what is expected of them in their role and what would happen potentially if they weren't to meet your standards. Now, I'm not saying you go in heavy-handed at the very outset, but it is helpful to make sure that everybody's aware of the standards expected and what you would do to manage any issues around poor performance. We talk about proper training and supervision, which is, as we all know, key in achieving satisfactory performance levels. And we should always be forthcoming in giving employees help and encouragement to reach the standards you expect from them in their job role. So that can look like giving regular feedback on things that are going well, and also picking up on things that need to be improved upon and dealing with that in the early stages informally, but also keeping good records should you need to rely on them later on. Probation periods are a really useful tool for you to help someone not only settle into their role, but also make sure that they receive the training during that period to be able to, perform and be successful in their job role. So we always advise that utilise the probation period effectively, make sure you have regular reviews booked in with your employees, and make sure that you follow up on those reviews. If there are issues identified, make sure you set further reviews and you follow up to make sure that that person is receiving the support they need to meet the standards you expect from them. If an employee fails to perform to the required standard, the matter should be investigated before you make any decisions about what to do next, because what you want to do is understand the reason for poor performance. And so police investigations. So I just want to touch on this. This is something we deal with often and certainly something I've dealt with a lot this year. But if the police are carrying out a criminal investigation into a matter that is also the subject of an internal disciplinary investigation, then you as employers should be careful that your own investigation doesn't prejudice or disrupt the police proceedings. However, an employee may be less likely to cooperate with an internal investigation if they believe that it could prejudice their defence with regard to the police investigation, but it may be that you're not able to hold off on conducting your own investigation depending on the circumstances. Again, I always advise, if you are dealing with a matter where you believe you should conduct your own workplace investigation and the police are involved, that you should take legal advice to ensure that you mitigate as much risk as possible in dealing with that particular situation. Now, an employer can carry out its own reasonable investigation as far as the circumstances allow, and it shouldn't rely solely on the outcome of any police investigation. So if you've got a situation where the police are involved, you shouldn't wait for the police investigation and rely on that solely when you're making decisions about what you do next. If the police investigation doesn't result in prosecution, an employer could still conclude that disciplinary action is justified on the basis of its own investigation. And this is because criminal proceedings require allegations to be proved beyond all reasonable doubt, whereas in an employment setting, an employer has to show only that it has had a reasonable belief that something has taken place. So we work on the balance of probabilities, which is that it's more likely than not by 50% that something has taken place. If a police investigation results in prosecution, it would generally not be necessary for the employer to await the outcome of a criminal trial before deciding whether to take disciplinary action based on its own investigation. Now, we say this because if anyone who has dealt with matters that are being investigated by the police, a police investigation can take many, many months, and it may not be appropriate for you to wait for that investigation to conclude, particularly if you're looking at a situation where you're having to consider suspending someone. So it might not be reasonable for you to put on hold your own investigation due to the time constraints. So that is something to bear in mind. What I would always say is, if you are dealing with something where the police are involved, absolutely take advice to make sure that you are mitigating as much risk as possible in the circumstances. So I just want to move on to conducting a disciplinary hearing. So there are no set legal rules to be followed for the hearing itself, and a lot will depend on the particular circumstances and whether you have set out any procedural guidelines, as discussed earlier when we talked about rules and procedures. So to avoid any allegation of prejudice, the hearing should ideally be conducted by an independent person, and you've probably heard this 100 times before. That is really important. So that is someone other than the person who made the complaint against the employee or who carried out or was involved in the investigation stage. So that is really important. The person should be impartial, so they should have no personal interest in the outcome, financial or otherwise. Now, in some cases, and we work with lots of small organisations, if you know, in a small business, it may not be possible, or it may be difficult for you to be able to separate out those roles, i.e. someone conducting the investigation versus the person hearing or chairing the disciplinary hearing. So you then need to make decisions about how you can make sure that process is as unbiased as possible. It could be that if you are in a small organisation, you might consider using external HR consultants or firms such as Frettons to support you with those processes, i.e. conducting an investigation or chairing a disciplinary hearing. But that is something to consider. But best practice would be that you would have two separate people to look after the investigation and more latterly the disciplinary hearing. It's also important to remember that the person chosen should have the authority to impose any relevant penalty, and they should act in good faith when chairing a disciplinary hearing. So again, that's something to bear in mind and consider. So during the introductory stage of a disciplinary hearing, the person conducting that hearing, who should be, as I said before, a manager with the authority to take disciplinary decisions, they should introduce everyone present at the hearing and explain the reason for their attendance. That would include anybody taking notes, for example. They should confirm that the hearing is a disciplinary one and that it is to consider whether dismissal or any other disciplinary action should be taken. And they should explain how the hearing will be conducted so that everyone present understands what is going to take place. The person conducting the hearing should then explain the nature of the complaint. They should review the evidence that's been gathered at the investigation stage, and they should give any witnesses an opportunity to comment. They should also ensure that the employee and their representative is allowed to see any witness statements or is told very clearly of the allegations and evidence that has been raised and is going to be relied upon. So ideally, you would make this available to them ahead of the disciplinary hearing. The employee should be invited during the hearing to state their case. They should be invited to ask questions, and they should also be given the opportunity to present any evidence and to call any witnesses. If witnesses are unable to attend the hearing should be adjourned unless it's clear that their evidence will not affect the substance of the complaint itself. So that's really important. If the respondent says that they want to call witnesses, ideally you would adjourn unless you can satisfy yourself that the witness testimony of the witness who was not available would not fundamentally change the substance of the complaint being considered. You should consider any explanations or other special circumstances put forward by the employee, and that is really important. You don't want to overlook any representations they make. If they've not offered an explanation, they should be invited to do so. So if if a respondent has attended and they've not offered any explanation, say, concerning their conduct, you should explore that with them and ask them to make any representations for you to take into consideration as part of your decision-making process. Your approach during the hearing should be formal but polite. So it is a formal process, and you want to honour that process by behaving appropriately during the hearing. You should use a mix of kind of open-ended and closed questions as necessary, really, to clarify all the issues that you are considering at the hearing. If it becomes clear that the employee has provided an adequate explanation, or that there is no real evidence to support the allegation, the proceedings can be stopped, and then you can confirm the outcome in writing. If new facts emerge during the hearing, the employer, so you guys as employers or business owners, must decide whether further investigation is required, in which case the hearing should be adjourned and then reconvene later on once those further investigations have been completed. So that is important. If new issues arise that need further investigation, absolutely adjourn and take the time necessary to gather the additional evidence that you need. If the employee becomes upset during the hearing, they should be given time to compose themselves before continuing. So I often will allow people to have a break. If it's not possible to continue the hearing, it should be adjourned and then resumed at a later stage. I have done that a handful of times in my career where someone has become so upset that it really wasn't possible to continue because they wouldn't have been able to contribute in a meaningful way, and that is really important. So don't be afraid of taking an adjournment and reconvening at a later date if you feel that is necessary. At the end of the hearing, you should summarise the main points concerning the offence that you're considering, the main points raised by the employee themselves, and any matters that need to be checked or investigated further, as the case may or may not be. And then I want to talk about the decision and the outcome. So unless the case is particularly straightforward, the hearing should be adjourned before a decision is reached. So depending on the circumstances, I'll always say it's good practice to adjourn for at least 24 hours, sometimes longer if they're particularly complex matters at play that you need to take into consideration. I think to take a short adjournment and then reconvene on the same day and make any decisions, particularly around dismissal, could prejudice your position in terms of mitigating risk. So I think it is good practice, and I always advise my clients that don't make decisions on the day. Take the time necessary to consider all of the information that you've gathered during that hearing, and then you can communicate the outcome to the individual concerned in writing later on. That also gives you the opportunity to conduct any further investigation to satisfy yourself that you are fully appraised of the circumstances and you've gathered all the relevant information and evidence that you wish to rely on when you're making your decision. The employee should be told about the result of any further investigations, and they should be given the opportunity to respond. So if you need to go away and do additional investigation work and you gather more evidence, it's important before you reconvene and make any decisions that you allow the respondent the opportunity to look at that new evidence and to comment on it. If the facts are disputed, then the manager conducting the hearing should decide which version is more probable, and we go back to the balance of probabilities. So something more likely than not having occurred, and it's got to be greater than 50%. So that's really important to bear in mind. And then an important point to consider, and I've actually, funny enough, dealt with something fairly recently, is do workers have the right to be accompanied at disciplinary hearings? Most of us on this webinar will know that yes, they do. Section 10 of the Employment Relations Act 1999 provides for the right to be accompanied at formal disciplinary hearing by either a trade union representative or a fellow worker. That being said, I have dealt with circumstances where I have allowed, for example, a relative to attend because the person that I was meeting with, that English wasn't their first language, for example, or they didn't feel able to ask a colleague to go with them. So I made allowances to make sure that they were accompanied and that they were able to participate meaningfully through any disciplinary hearing. So it's always good practice to absolutely follow the guidelines, which is, a trade union representative or a fellow worker. But if you feel that you need to adapt that, depending on the circumstances, there's nothing wrong in doing so, as long as you're clear with the individual who's accompanying the respondent what their role is during the hearing. So be nice and clear with the boundaries during that process. Make sure you explain at the outset of the hearing the role of a companion and what they can and can't do. Okay. And then an important point at the conclusion of any disciplinary procedure, whether you're making a decision to dismiss or whether you're giving any other warning or sanction, is that you give the individual the right to appeal. This is particularly important if the individual has more than 2 years service. So if you're dealing with matters relating to someone who has 2 years of service, you should give them the right to appeal. And that gives them the opportunity then to set out their appeal in writing to you. Ideally, at the appeal stage, you would appoint an appeal officer who has had no involvement in proceedings before. Again, I appreciate that in smaller businesses that may be difficult. And if you are in a situation where you don't have anybody else who hasn't been involved to be able to deal with the appeal, you could consider outsourcing that to a local HR consultant, again, firms such as Fretton Solicitors, as an example. Or it may be that you decide that actually you're going to proceed with the resources you have available to you within the business. And if the person who is hearing or handling the appeal process has had previous involvement in proceedings, they need to be very cautious that they don't make any decisions that could leave themselves exposed to complaints of bias or prejudice against the individual concerned. It's really important in a disciplinary procedure that you do cover off the right to appeal. It's typical in those procedures that there's a timeline set for the individual to submit their appeal in writing. It's normally 5 days. Sometimes it can be longer, but I recommend 5 days. That's typically sufficient. And it should make clear that the employee must submit their grounds for appeal in writing, and then you can follow the process from there. But it's something worth not overlooking. I've recently dealt with a matter where an organisation, a client organisation, had dealt with a disciplinary matter, and they drafted a disciplinary outcome letter, but they forgot to state the right to appeal. So it's really important that you make sure at the end of any disciplinary proceedings that you do capture that right to appeal and you set it out in the outcome letter. And that brings us to the end of the webinar. I appreciate it is a whistle-stop tour, and I've tried to cram in lots of useful information, but we can't cover everything, but we have got time for questions, if there are any, Jo.
Yeah, there's a few little bits. Just bear with me a second. Okay, so some of these are referring to some of your slides earlier on, Nathan.
I can go back to the slides, yeah.
Bill's asked, can you explain the importance of the disciplinary policy itself, from which procedures and processes are derived from, and the importance of management stroke HR? Oops, hold on a second. Following these to maintain good ER relation with both staff and unions.
Yeah, I mean, a disciplinary policy is a really important document. Is something that I will always refer to. So if I'm advising clients, where a client will contact me for advice, the first thing I say is, do you have a disciplinary policy? I ask them to make that available to me. We check the contractual status of that policy. But the importance of the policy is it should give you a robust framework for you and your managers to follow when handling issues. So when you're dealing with any issues around misconduct, for example, or gross misconduct, as the case may be, essentially the process you follow when dealing with those issues shouldn't come as a surprise to your employees, because they should be clear and understand that there is a process that you've set out in your policy that you will follow. Again, just looping back into the piece around the contractual status, it is important to make sure that your procedures, your disciplinary procedures, are non-contractual, because that gives you a level of flexibility in handling matters. I'm not saying you should disregard your procedures if they're not contractual, because again, that could damage trust and confidence between the business and its employees. But if your procedures are contractual, and as I said before, you don't follow them to the letter, you could leave yourself exposed to a breach of contract claim. So that's really important. But a well-drafted disciplinary policy that has been formulated in the right way, that's got people involved. So if you've got employee representatives or you're working in a trade union environment, get your union reps involved if you haven't got a policy in place and you're drafting one, get them involved, get their input, because ultimately what you want to do is be in a place when you approve your policy that you've had other input from the workforce, and they've been able to make suggestions about what should and shouldn't be included. Now, don't get me wrong, I'm not suggesting that you should allow your employees to make unilateral decisions about what you include in your disciplinary rules and procedures, because ultimately that document is there to serve as a toolkit and a framework for the business when dealing with issues. But it's a really important document, and it's one that should be, you should give time and attention to if you're drafting one for the first time. Equally, if you've got one in place and you feel that it's dated and needs to be updated, again, if it's non-contractual, the process of updating it is more straightforward. If you've got a policy that is contractual and you want to update it, then you're in the realms of consulting. That being said, if you're updating any policy or procedure, my viewpoint is always that you should consult with people. You should talk to them about why you're making changes or making updates. And you should, if you've made updates to a particular document, you should certainly issue the new document. You should be clear with employees what has changed, what's been amended, and you should give them a period to be able to review that and confirm whether they're happy with the changes that you're making. I hope that answers your question.
You might have actually answered the next question. I'm not too sure. So Kathy's asked, I believe you mentioned when looking at the disciplinary rules slide that these can be contractual, but you then mentioned that the disciplinary procedures can be non-contractual. What are the differences and what do you mean?
Let me go back to make sure I'm answering the right. Was it the disciplinary rules slide, did you say, Jo?
Yes.
Yeah, so your disciplinary rules, essentially, they are setting out the standards that you require from your employees in practice and when they're at work. And we always say that your disciplinary rules, let me go back one. It's your disciplinary rules, which should be your contractual terms, because, for example, if an employee were to breach a disciplinary rule, it would be a breach of contract. But it's your procedures, so the procedure you will follow when handling disciplinary matters. So, for example, someone's committed an act of misconduct or gross misconduct, you're then going to follow a process which will include investigating, inviting them to a disciplinary hearing, etc. They're your procedures. You don't want those procedures to be contractual, because essentially it means that you can't deviate from them. And whilst I'm not saying you should deviate from your procedures unnecessarily, you do want a level of flexibility. So, rules are the standards you're expecting from your employees, and I would recommend they're contractual, because if an employee breaches them, then there's a breach of contract issue, which you can then address. But it's your procedures that shouldn't be contractual, because you want to allow a level of flexibility. Does that make sense?
Okay, thanks, Nathan. So this question came up when you were talking about poor performance. So I think it's relating to this. So Jose's asked, would PIP be useful for cases in poor performance?
Say that to me again, Jo. I lost you there. You broke up.
Sorry, this was when you were talking about poor performance. So Jose's asked if PIP would be useful in cases of poor performance.
Yeah, PIP documents are really useful. If they're used in the right way, performance improvement plans can be a really useful tool in dealing with performance issues. Certainly, if later on you're going to have to deal with things more formally, because they kind of set the foundations for what follows next. So they shouldn't be seen. I mean, it makes it sound like I'm saying they're a tool you should use to gather evidence and be able to potentially use it against someone later on. And I don't mean it in that way. I think a performance improvement plan used in the right way should hopefully see that an employee improve, and hopefully you won't need to take further action to get, with that individual. But should you need to take formal action later on, a performance improvement plan is a good way of you being able to refer back to conversations you've had, plans you put in place, support you provided the employee. All of those things are really helpful when you maybe are having to make decisions later on about what you do next if you see no improvement. So I think, yeah, I'm a big fan of performance improvement plans. That being said, performance improvement plans are only as good as following up on what's been agreed. So if you say that you're going to hold reviews, in 2, 4, and 6 weeks, is making sure you hold those reviews and that they're documented and that you follow up on any comments made by the employee, and that you also make sure that you follow up any comments or promises or obligations you make to the individual as part of their performance improvement plan.
He's also asked, where would you include return to work interviews, and is there any issue with them?
Return to work interviews, again, I like return to work interviews. I think as long as you're consistent with them, they should be done after every period of absence. So as soon as someone has been away from the business, whether that's for a sickness absence or it's a period of unauthorized absence, I would always do a return to work interview. Particularly important if someone's been away unwell, because that's your opportunity to do a welfare check and to make sure that the person is fit and well enough to return to work. That's even more important if someone's been off on long-term absence. So if they've been away from the business for, 4 weeks or more, I would certainly say absolutely you want to sit down with that individual, make sure that they've returned to full health. It's an opportunity for you to understand whether you need to make any adjustments in that initial return. So return to work interviews are really useful and can be really helpful, especially when you're dealing with issues later on. So if you've got somebody that has got unacceptable levels of absence, or you're potentially facing capability issues, return to work interviews, if you've captured the right information, can be really helpful. Again, it's not about using them as a weapon against the individual. It's about, capturing good information that you can use to make sure, at the outset that you're able to offer support where it's needed, but also if you have got continuing issues that you can then rely on that information later on to essentially manage effectively.
Thanks, Nathan. Will's asked, how do you recommend dealing with employees who are not engaging with the disciplinary process, i.e. not accepting invitation to the hearing, etc.?
Yeah, we see this a lot actually, and actually, funny enough, this year I've seen it as a growing trend. Look, you ultimately, as a business, you have a right to meet with your employees to address issues, and if you need to do that through a disciplinary procedure, then absolutely you write to that individual, you give them sufficient notice, and you ask them to attend. My approach is always, if someone says they can't attend, I'm always happy to reschedule. I will ask the reason why, and then I will reschedule. I certainly would always give one reschedule within 5 working days, because I want to be seen to be behaving reasonably towards the individual. But if someone is persistently refusing to turn up, so for example, if you've rescheduled a hearing and on the second occasion they haven't turned up, or you're on a third occasion where they haven't turned up, you may be in a situation where you're going to have to start thinking about, do I hold the hearing in their absence? And do I make decisions in their absence? Now, if you're going to do that, what I would do is absolutely, if you've got someone saying, look, I can't attend the hearing on the date you've requested, then reschedule within 5 working days, or it could be longer. Be reasonable. That's what I always say, is be reasonable with the individual. But if they reschedule for a second time, I normally allow that. I will say, okay, fine, I'll reschedule for a second time. But thereafter, I start to get nervous about, is this a delaying tactic? And that's not helpful to the process. It's not helpful for the business. It's not helpful for the employee. If you feel like you're in a position, and I don't know the circumstances of the particular matter you're referring to, but if you feel like you have been reasonable, you've offered rescheduled appointments, and that person is still refusing to engage with you, it might be that you need to write to them and say to them that you're rescheduling for one last time. You give them the date and the time of the meeting as you normally would in a standard letter, but you advise them that if they fail to attend, it may be that you will have to hold the hearing in their absence and make decisions based solely on the information you have available to you, which will be without the benefit of their representations. So as long as you make it clear to them, I haven't got an issue with holding a hearing in their absence, but I wouldn't do it hastily. I would at least make sure I've demonstrated that I've rescheduled on 2 or 3 occasions. That's my viewpoint.
Okay, brilliant. Thanks, Nathan. Caroline has asked, who decides who has the authority to take action? If all managers are trained in investigatory and disciplinary procedures, surely they can all make appropriate decisions, i.e. be able to dismiss if that's a fair outcome.
Yeah, I mean, it's for the business to decide. Ultimately, the business should have, when you're formulating your policy, it's for the business to decide who has the authority to dismiss. In lots of organisations we work with, it will be normally a senior manager. So you might have a department manager, for example, who can chair disciplinary hearings up to and including a final written warning. And it might be that the only people within the business who can make decisions around dismissal are senior managers or a certain grade manager, for example. So it is for the business to decide who has the authority to make those decisions. And as I say, it can be tiered. It can be based on level of seniority. For example, we've got other clients where they don't have a large management team, and actually, all the managers within the business can make decisions on who should dismiss, for example. So it is up to the business.
Rebecca's asked, would you give the case back to the investigation manager to investigate, or could the hearing manager do this?
No, I would say you can do one of two things. Yes, you could go back to the investigating manager and say, there's new information that has, emerged at the disciplinary hearing, and we think these matters need to be explored further. Now, I want to be clear as well, these should be matters that are related to the allegations that have been made against the individual. They shouldn't be new allegations that we want to add onto the list, if you will, of either misconduct or gross misconduct matters that you're looking at. So as long as the new issues that you want to explore are related to the original allegations, that's fine. And yes, you could give it back to the investigating manager or officer and say, look, can you go and explore this for me? Or if they're straightforward, the person chairing the disciplinary hearing could go and do that themselves, because ultimately what they need to do is make sure they satisfy themselves that they have all the information they need to make an informed decision, which is fair and reasonable in the circumstances. I hope that answered your question.
Nancy's asked, how would you recommend managing the disciplinary process when the employee goes off sick with work-related stress due to the process? Getting the balance between being supportive and not unreasonably delaying the process.
Yeah, I mean, this is an interesting one. I see again. I think it's a growing trend that I often see when we invite employees to disciplinary hearings and they do go off sick. Sometimes it can be genuine, where someone says, "Look, I'm stressed. I've got anxiety," and it could be that that's been triggered by the prospect of going through a disciplinary procedure. Again, I always say be reasonable in the decisions that you take. Ultimately, being signed off as unfit for work is different than being signed off as unfit to attend meetings. So while the individual might not be fit to attend work and to do their job role, it's quite unusual for a doctor, in my experience, to specifically say that person is not able to attend a meeting, which is probably likely in most circumstances to last no longer than 2 hours maximum. I mean, if the disciplinary officer is well prepared, then they should simply be presenting the allegations and the evidence they've gathered at the investigation stage. Well, not them personally, but the investigating officer. They're presenting what's been found, and they should be inviting the individual to comment on that. So the meeting itself, unless it's particularly complex, shouldn't be onerous. So yeah, being signed off as unfit for work and being signed off as unfit to attend meetings are two separate things. What I would say is I wouldn't necessarily, in the first instance, say if someone signed off for 2 weeks, I might allow them the 2 weeks. But that's thereafter, I might say, look, we need to hold this meeting with you. If the individual signed off with work-related stress and we think that work-related stress is connected to the matters you're trying to deal with through the disciplinary procedure, my view is that actually it would be in the individual's interest to attend the hearing and to engage so that you can conclude that process, and hopefully that will reduce their levels of stress. So again, it is acting reasonably in the circumstances, but ultimately, yes, matters can't be left open-ended. And I would always recommend, depending again on the circumstances of your particular matter, it may be that you say to the individual, look, we need to conclude this matter. We want to invite you to attend a disciplinary hearing. Again, you're probably going to have to reschedule, but I would absolutely do that and show that you behaved reasonably. But you might get to a stage where you have to start thinking about, do I hold any disciplinary hearing in the individual's absence? One thing I always do, though, in these circumstances is if someone says to me, I'm not able to attend, then I always say to them, can I make any adjustments that would make it possible for you to attend and engage meaningfully at the hearing? If they say no, then the other thing I offer is, would they be prepared to submit written submissions to me for me to take into consideration anything that they feel is relevant. Bearing in mind at this stage, you'll have already written to them, inviting them to the disciplinary hearing. You'll have made available to them the evidence you're going to rely on at that hearing. So they will be appraised of the situation, the allegations made against them, the evidence you've gathered. So it should be fairly straightforward for them to make any written submissions to you. But as always, if you're dealing with a particularly complicated case, get advice. That's what I'd always say, so that someone can talk to you about the specifics of your case and give you the most appropriate advice.
Thanks, Nathan. A couple of questions about this. So Joel's asked, and then Kathy's asked something very similar. If you're taking an agency worker or casual worker through a disciplinary procedure, do you not risk treating them as an employee? Should an agency worker's conduct be dealt with by the agency?
That is a good question, and it's something I always say I would take advice on. It depends on the circumstances that you're dealing with. I mean, if you're dealing with an agency worker that's come to work with you on an agency on a temp basis, it's often easier to go back to the agency and say we don't want that individual to come back for the following reasons, and you can inform the agency. So again, I would always say take advice, because they can often be complex matters. But yeah, if you've got someone on an agency, as a temp through an agency that you use regularly and you've got a good relationship, if there are issues, document the issues, contact the agency. But yeah, absolutely, if you think that there's any potential risk, then I'll take advice. I hope that answers your question.
So Caroline's put, what is frustrating is when people appeal with no new evidence, just to appeal. Can an appeal be refused?
I would never recommend refusing an appeal. I would always look at it, even if the outcome is that the decision still stands. So I would say no, I would never advise that you refuse to hear an appeal. As long as the employee complies with your disciplinary policy, which should have a section on the appeal procedure, and typically that is that they should submit their appeal in writing, and they should set out their grounds for appeal clearly, so you understand why they are appealing, and then you consider it. And if essentially the outcome is the same, then the appeal officer can say, actually, we uphold the original decision. So I agree with you, and we can see this that sometimes it feels like people don't take the time to consider why they are appealing, and as you say, it can feel like they're doing it for the sake of it. But I would always follow the process, because if you don't, it's likely that it could come back and bite you.
Thanks, Nathan. I'm just conscious of time. We've only got a couple more questions.
I'm fine for time. I've allowed extra time, so you're fine.
Okay. So a man was asked, is there anything that needs to be considered differently for volunteers?
So for volunteers, did you say?
Yeah, volunteers, yeah.
Yeah, I mean, volunteers, it's not something we'll necessarily get into today, but yes, if you are working within an organisation where you have a bank of volunteers, then you absolutely would want to have specific policies in place that manage the relationship your organisation has with volunteers. If you want specific advice, I'm more than happy for you to drop me an email. But yeah, that's slightly more complicated if you're dealing with volunteers.
This is the last one, unless anybody else wants to pop anything in the chat. Lucy has asked, should return to work interviews be carried out by HR or their manager/supervisor?
Look, it really depends on your business. I mean, my preference always is that it's the line manager, because I think if you're line managing someone, they're your people, they're your responsibility. And so, it might be that you get HR supports, but I think it should come from the line manager, because the risk is the process is then seen as an HR process. And actually, it's not an HR process in the way that when people say, it's an HR process, they're talking about ownership. It's not, it's a management process. If someone's been away from work absent, you'd want their line manager to sit in an ideal world and to go through that process with them. But I work with organizations where it's HR that picks up that work, and they hold the return to work interviews. So it really depends on your organization. I suppose it will also depend on your line manager capability, and whether you feel they have the capability to conduct those interviews and to do it well. Because often, I always say there's no point completing a return to work interview if there's going to be minimal information included on the return to work form. So, if you're experiencing that, it might be a training need, but my preference always is that the line manager, they do that with their direct reports, because they're the one that's responsible for the individuals.
Okay, thanks, Nathan. That's the end of the questions, so perfect timing.
Okay, thank you very much for inviting me to deliver the webinar for you. I hope it was useful. I appreciate it's a lot of information to try and cram into a short space of time, so I hope I've done it justice and everyone's enjoyed it.
Yeah, no problem. So we'll send out some correspondence to everyone that has signed up for the event, and I'll put a post on LinkedIn. So if you would like a copy of the follow-up slides and the recording, then please put a comment against the LinkedIn post. Our next event is on the 17th of October and is called Understanding and Conquering Imposter Syndrome for Leaders in the People Profession. And a link to sign up for that will be included in the email. If anyone is recruiting, we've also got accountancy recruit, FD recruit and exec recruit in the group. But otherwise, I'd just like to say a massive thank you to you, Nathan, for putting your time and effort into holding the event, and for everybody for tuning in. Thank you.